Buying and selling realty. An overview. Chapter 1 is an overview of how the typical purchase and sale transaction is phased from start to finish. For readers encountering the real estate sales process for the first time, their eyes may glaze over as they try to imagine what really transpires in each stage of the process. The pivotal document in a typical realty sale is the purchase and sale agreement, whether the property is a modest tract house or a downtown office tower. One difference, though, is that broker-drafted forms are likely to be the document of choice for most houses and rental properties with fewer than 50 units. While attorneys are usually called upon to draft purchase and sale contracts for multi-million-dollar commercial properties. At the end of the first chapter, there is a form drafted for use as a purchase and sale contract for commercial real estate. It comes with escrow instructions jointly agreed by seller and buyer. This form is worth reviewing for the many issues it resolves and contemplates, besides the obvious ones of identifying the parties to the transaction, the subject property of the sale, and the purchase price. A far less comprehensive purchase and sale contract would still be enforceable. To be enforceable, an agreement needs to meet certain requisites of contract law. And if the agreement concerns real property, state laws called statutes of frauds require that it be in written form. This manual offers a summary of the contract law norms and statutes of frauds provisions that figure in determining if a realty purchase and sale agreement is enforceable in court if the buyer or seller decides not to complete the sale. Disregarding these laws, buyers and sellers who have a falling out may discover that their deal is unenforceable. Realty buyers may be drawn to a particular property even though they might not be completely sure that the property is exactly right for them before they have had a chance to check it out. Most potential buyers are reluctant to spend time and money learning about a property until they have obtained a legally enforceable right signed by the seller to purchase it for an agreed price. But sellers are wary of signing binding contracts with potential buyers who are just shopping around before they have learned anything about the buyer's financial ability and past real estate dealings. They need to agree to a purchase and sale contract that addresses their reciprocal concerns by including exit contingencies. Or they can bargain for an option agreement giving the buyer the right but not the obligation to purchase the property. The text describes the subtle differences between a call option and a contingent purchase and sale contract, and why a buyer or seller would prefer one over the other.